be very respectful of your time and get you out of here by noon. Fortunately for HR, we have an opportunity through returning staff orientation to share updates related to the HR policies with you. Also in our employee handbook, we have kind of an abbreviated policy section, so staff, they're pretty much made aware of changes in human resources policies. So today what I'm going to do is just cover, because there are a lot of policies in the personnel section, I'm only going to cover policies that have changed over the last year and a half, 2 years, those that I thought were important for you to be aware of. The first policy, DC, it covers criminal background checks. We are required by law to conduct criminal background checks on all of our employees. In addition, and that's in accordance with Senate Bill 9, and then for some other areas where there are other laws that dictate that we must conduct criminal background checks. So we're required to do fingerprinting of all staff we hire. In addition, HCDE has adopted the practice for like student interns, people that will have exposure to students, that they also have a background check conducted, especially those interns or volunteers that may have an opportunity to work, they'll be alone with a student. We can't afford to take any risk. Now, for some programs like Head Start, we may not conduct as extensive as a background check like fingerprinting, because most of the time, the volunteers, they're not left alone with students. But you can have an OT intern or a speech intern. They may have an opportunity where the therapist they're working with maybe has to step away, something as simple as a restroom break, or to have a conversation with a parent or a teacher. And so it's important that we make sure, staff and volunteers. Now HR, we're responsible for making sure that we do background checks on all of our applicants that we are offering employment to. We don't know who your student interns are, who your volunteers are, so that responsibility falls on the shoulders of the supervisors. So you need to make sure that background checks have been done on those individuals. Even if you send a form over before you have a person come and work, you need to make sure that we have the results back and this person has been cleared to work in your program, because it only takes, one time, one mistake, and we can't afford that. What's new in this policy, and I underlined it, for our AmeriCorps program through CASE, we were required to spell out in our policy that we do background checks on members that are volunteering or working in the AmeriCorps program. So that's the only change in that particular policy. DEC, under leaves and absences, we have the board awards personal leave to all eligible employees. So there are, if you earn between 10 and 12 personal leave days each year, there are some restrictions on the use of personal leave days when it's related to discretionary leave. When you're using a personal leave day, let's say to take care of some personal business, or to attend an award ceremony at your child's school, or to take care of something related to your car, that's considered discretionary personal leave. And there are some restrictions in terms of the number of days employees can use each year. Non-discretionary personal leave, that's used for things like illness, injury. There are no limits with regards to non-discretionary leave. In the policy, there was a reference to family emergency. So the policy was updated to try to define what constitutes a family emergency. So it's limited to disasters and life-threatening situations involving the employee or the employee's immediate family member. And an immediate family member includes like the employee's spouse, any children of the employees, parents of the employees, as well as siblings. So it's limited. Bereavement leave, again, we don't award true bereavement leave like some private companies may give employees a certain number of days for death in the family. Employees can use personal leave for bereavement. The policy changed before. Employees were limited to 3 days with approval of the superintendent for more. Now the policy specifies that employees can use personal leave days, and again, this would be considered non-discretionary personal leave days, for death in the immediate family, an employee should not exceed 5 days. So no one in the department, not even the superintendent, has the authority to approve in excess of 5 days. And again, and that's non-discretionary. Something else that was added to the policy, additional local leave does not accumulate while an employee is on unpaid leave. The policy before stated that you have to work at least 10 days in a month in order to receive, to be awarded a personal leave day. The policy is just clear now. If you're not working, you will not accumulate local personal leave day. Under the vacations and holidays, again, if an employee is on leave status without pay, vacation days do not accumulate. If you're out on leave for 3 months out of the year, you're not being paid. In January, when vacation is awarded, an employee will receive a prorated number of vacation days, not the full amount. So again, that's just was made clear in the policy. And employees may not use vacation time to work for an independent school district or other governmental entity. I don't have in the presentation to discuss if an employee has employment outside of HCDE, you are required to complete and submit a notice of outside employment that must be approved. And especially if you have an opportunity, to work, if you're working for another district or you're working for some other governmental entity, you need to make sure that you have a form filled out, signed by your supervisor or your division director, and then signed by the superintendent. If you're working for an ISD or other governmental entity, and it has been approved, you have to take a day without pay. You can't use a vacation day and go and work for any of those entities.
Natasha?
Yes.
I was just looking at one of those forms the other day, and it says that the supervisor keeps the original and HR keeps a copy of it, but because it has to be signed by the superintendent, is it supposed to be sent back after the superintendent's signature to the supervisor? Or
No, I think it must be an error on the form. The original should be on file in the human resources.
So even if it's the reverse, if the supervisor keeps a copy, then it would be prior to the superintendent's signature, or is it, how would a supervisor have a signed copy is what I'm asking? Do you know what I mean?
Typically, we don't send the form back unless there's a problem, unless it's not going to be approved. And normally there's a note as to why, or in most cases, there's a conversation that occurs either between the superintendent and the division director. And so the employee is advised if there is a problem. But normally the form is just filed in human resources.
Okay. So just keep a copy prior to submitting it.
Yes. This policy, DFBB, it relates to our Chapter 21 employees. So these are our employees working in the special schools divisions, like our principals, teachers, counselors, those individuals that are required to have a certificate through the State Board of Educator Certification. So this doesn't apply to the vast majority of our employees. Only about probably 10% of our employees are SFAC certified or required to be SFAC certified. But the policy was updated about a year and a half ago. The law changed. Before, if we were going to propose non-renewal of a certified employee, we had to give them notice 45 days before the last day of instruction. The law was changed, and so now we're only required to give them 10 days notice before the last day of instruction. So the policy was updated to include the change in the law. And again, in the notice of proposed non-renewal that we give to the certified employee, the employee has a right to request a hearing regarding the proposed non-renewal. In the notice, we must notify them if the hearing will be before our Board of Trustees or before an independent hearing examiner. So we're required to put that in the letter. And so the policy was updated to include those changes in the law. DFFA, reduction in force. Prior to the change in this policy, we had a policy, DFF, that addressed reduction in force due to financial exigency. as well as due to program change. So the policy was divided. So now we have a policy DFFA that deals with financial exigency, and then DFFB that deals with reduction in force due to program change. So the policy was divided since those areas are completely different. So if the superintendent determines that we have to reduce personnel costs, of course, the board has to approve that, so a recommendation has to be made to the board, and the board has to approve it. Now, this policy, well, I guess it addresses, it really applies to all staff, so whether you're a contract employee or at-will employee, it applies to all staff. So, salary reductions can occur if that's a recommendation made by the superintendent to the board. Furloughs can occur. However, we have to have certification from the commissioner that there has been a change in program funding, formula changes. So if it's determined in order to make the budget, staff need to be home for 5 days and not get paid for that, that requires certification from the commissioner. It's not something that the superintendent and the board can just determine that we'll do in order to balance the budget.
Now, what commissioner is that?
The commissioner, TA.
Okay.
Yes. Yes. Thank you. You're welcome. And again, when it's been determined that a reduction in force is going to occur, we have to determine the areas that may be affected. It can be, I guess, the entire organization, or it can be an individual campus. It could be certain Head Start centers. It could be certain internal support divisions. Let's say by chance, some of our major divisions had to reduce staff and cost. It's possible, if we lose, half of Head Start and half of ECI, half of therapy services, then we don't need as much support from the technology division, from the human resources division, from facilities. So it's possible if we start to reduce some of our major programs and services, internal support divisions will be reduced as well. So in the superintendent's plan to the Board of Trustees, it may be identified that we also have to reduce some specific divisions. And again, if there's reduction in program funding, state or federal funding, that goes to the board for the board to approve before we implement a reduction in force. Then once it has been determined the areas that will be affected by the reduction in force, then next we start looking at the staff. In some situations, if we close a campus or a center, it's usually everyone that works at that particular campus or center is affected by the reduction in force. Well, sometimes maybe we have a reduction in funding where we're not closing the entire division, like we're not eliminating the entire HR division, or we're not eliminating an entire campus or center. So then we have to identify, the staff within that area that will be affected. And so the criteria that we have, it is the same criteria that we had before. What's changed is kind of the order of the criteria. So before, once we determine that we have to reduce X number of positions or certain kinds of positions, we would then look at the qualifications of staff holding those assignments, then any extra duties they may have, their professional background. Then we looked at seniority and then performance, but now the orders change. Now we're looking at performance. And when we're looking at performance, we're looking at appraisals, any written documentation, disciplinary warnings, verbal warnings, performance improvement plans that have occurred within the past 36 months. So it'll go back to about 3 years when we're looking at performance of staff to determine which staff will be impacted by the reduction in force. And this is reduction in force due to program change. And again, the board has to approve this type of reduction in force. A program change could be any kind of elimination, reduction, If it's determined that we need to reorganize a particular vision or reorganize a campus or a center, that's considered a program change, so a reduction in force can be implemented as a result of that. And again, this is very similar, or it's the same as DFFA. The areas that may be a part of a reduction in force as it relates to a program change. And then how we would evaluate the positions, the staff that will be affected. That's the same as well. Policy DGBA, Dr. Petrie gave this as an example when she was doing the search. This is related to our complaints and grievances policy. This policy is very time sensitive. There are lots of timelines that we have to comply with. As a supervisor, I know sometimes we try to encourage employees filing grievances to send those forms to the HR division so that we can document and keep track of time. Because if we fail to comply with time frames, the employee automatically proceeds to the next level. And it's our intent always to try to resolve the grievance at the lowest level possible. Employees are encouraged to go through kind of informal processes first before filing a formal grievance. But if a supervisor receives a grievance form and it sits on the supervisor's desk and nothing happens with it and a time frame passes, the employee automatically gets to go to level 2. And the level 2 is with the superintendent or his designee. And then the level right after that is with the board of trustees. So we don't have many opportunities to try to resolve a grievance if we don't comply with the timeline. So again, what was added to the policy is to kind of clarify the deadline. Employees have 15 days to file a grievance. So sometimes we will see on the 15th day at 8 o'clock p.m., 9 o'clock p.m., a fax would come through or it would get slipped under the door, and there was some debate about the time. So now the policy, a time was added to the policy. It must be received by 4:30 on the deadline in order to be considered on time. So as a supervisor, if you receive a grievance, hopefully every division has some sort of mechanism where you can timestamp items that you receive. I mean, you should timestamp it with the date and the time. But we always try to encourage employees to submit them to human resources so we can make sure. Another addition to this policy, we had a grievance, unfortunately, where we were debating whether an employee filed an appeal notice timely. In the letter that the employee received from me, it said, quoting policy, that the employee had to submit it on the 10th day following the date that the employee received the notice. Well, there was some debate about when the employee received the notice. So now, in the notice from Human Resources, it's very clear that if you wish to file an appeal, you must file an appeal by this date. So we include that in the letter so that we're not debating over whether something was filed timely or not. DH, Employee Standards of Conduct. The policy was revised to state that an employee may communicate with students electronically, so employees may text students, do instant messaging, blogs, but you must remember, number one, you should have a professional need to do so with students. It should always be educationally related, and it must be in compliance with any applicable law, so any state, federal laws, but the policy was modified to state that employees may communicate with students electronically, because that's just the world we live in today. But you are still responsible for complying with any administrative guidelines related to electronic communication. And then another addition, the employee shall be held to the same professional standards in his or her public use of electronic media as for any other public conduct. An example, we had a teacher. Oh my God, I'm trying to make sure we can. Okay, we had a teacher on Facebook after work hours on the Teachers on Time. made some comments, some inappropriate comments about a student or about a parent and a student to another employee. Well, I guess the two employees were friends on Facebook. Well, then the parent was friends with another employee, so was able to see the comments. And so was held responsible and, was terminated from the department. So you have to be careful when you're using social media, on your own time. You consider it to not be work-related, but it may be. If it makes you ineffective when you are at work, then it may be grounds for disciplinary action. So please be careful. So the policy was updated to include that language. Some other policies I just wanted to make sure you're aware, because we get lots of questions about these. Our absence control policy, any employee, does not matter who you are, the position you hold, if you are absent for more than 180 days in a school year, your employment is automatically terminated, unless you have accumulated personal leave. We have some people, they have lots of personal leave, they've accumulated over the years, and if they're out sick or they're out ill and they've exhausted family medical leave, they've exhausted temporary disability leave, they've been out for 180 days, but they have 220 days of personal leave. Well, their employment isn't terminated until they've exhausted all of their personal leave. But in most cases, for most employees, after 180 days that you have been out and away from your job, absence control kicks in and employees are terminated. And then in situations like that, we don't have it very often, but we have it, often enough. They do receive their advice before they go out on leave, especially if there's some question about the duration of their leave, that's a possibility. And then we, Human Resources, we send them formal notice citing the policy and why their employment is being terminated. And we also make the division aware. Yes, David?
It wouldn't apply to assault.
No, it doesn't, because different law. Assault leave, if a teacher, and this happens primarily in the special schools division, if a teacher is injured, because of the population that you're serving, that's why. If a teacher is assaulted by a student, and there's some legal definition of that, a teacher can be out for 2 years with full pay and full benefits, no loss of pay and benefits. So, absence control does not apply as it relates to someone being designated as being on assault leave. Okay, criminal history reporting, just something. Oh, yes, Benita?
Would you please address hardship situations where you may have somebody out that's 180 days, or maybe less than that, but it becomes a hardship on the program? Could you just address how that might possibly work? How that works?
Well, it depends on the type of leave that the employee is under. If it's family medical leave, employees have 12 weeks, up to 12 weeks to be out. They are guaranteed a position upon their return. So we cannot terminate someone or fill the position, even if it is a hardship. We can get someone in to cover until they return, but we have to have a position for the employee when they return. Temporary disability, if an employee goes out on temporary disability, the law does not provide guarantee that the person will come back to the same assignment that they had. In most cases, we do try to hold the same assignment. So we may be able to, under temporary disability, fill that person's position, and then when they return, put them in a comparable position at a different center, at a different campus. So, depends.
Okay.
All right, so criminal history reporting, just something to remind you of. If an employee has been arrested or convicted, especially if it's related to a felony offense, they must notify the supervisor or human resources, or they are subject to termination. Well, they will be terminated if they fail to notify us. So if someone's been arrested and they're locked up, and they want to keep their jobs, they better make sure a family member or somebody calls within 3 days and notify us of legal arrest. Again, immediate family member, there's always questions about who's considered an immediate family member. Again, it's a spouse, child, grandparent, sibling, grandparent, or grandchild. I know it's different for family and medical leave, what they consider an immediate family member, but in terms of the policies that reference immediate family member, those are the individuals we're referring to. Other court appearances, we get lots of questions about this. Employees are paid when they go out on jury duty and they receive a summons and they return the summons when they come back to work, and it's turned in with the attendance reports. If an employee receives a subpoena and they have to go to appear in court on behalf of HCDE, so if it's related to HCDE business, then the employee is not charged. It's not charged against the employee, or their pay is not docked. But if an employee receives a subpoena for something that's not related to HCDE, it's non-HCDE business or non-Head Start business or not related to any of our programs or services, then the employee is required to either use their own personal leave or vacation time, or they're docked without pay if they don't have any accumulated leave. So I know sometimes we get lots of questions. People are confused because, well, the employee had a subpoena. Yes, they had a subpoena because they witnessed a car accident or they were involved in something of a personal nature. If it's not related to HCDE, they must use their own leave time or be docked without pay. Again, working while on leave, employees may not work while on leave, and it includes work as a consultant, because sometimes people they may have a job someplace else and they're called a consultant. If you're on leave, you should not be working. And Social Security numbers, we get a lot of questions about this, and we see a lot of mistakes being made. Legally, we are required to notify our employees under what statutory authority we collect and use and provide their Social Security numbers. So in our local board policy, we state that we use your Social Security number for reporting to the IRS, for reporting to TRS, for reporting to the Office of the Attorney General when they're trying to track people down for back child support. And so we list, I think there are about 11 reasons we list for criminal background checks. Sometimes some of you may get calls, especially if we provide services to ISDs. You may get a call and they may ask for an employee's Social Security number so that they can do their own background check. You should not give anyone an employee's Social Security number, even if you do somehow have it in your possession or in your division records. An example, if a district calls and they want an employee's Social Security number so that they can perform their own background checks, which really they don't have to, because once an employee is fingerprinted, they're in a database, and any authorized user, ISD, they can access the record of that employee, so they don't need the employee's Social Security number. They have access. But sometimes they want it just to make sure they have the correct person. Do not give the Social Security number. You can get the employee to call the school district, and if the employee is willing to provide their Social Security number, that's fine. But we really should have the written permission of the employee before we give their Social Security number to anyone, because you are now violating, laws by providing their Social Security number. You may be creating some security, identity theft issues by providing their social. So please be careful with Social Security numbers. If you ever have a question whether you should give someone, a child care, a licensing rep, someone's Social Security number, please do call before you give the number so we can make sure we're not making any mistakes. Okay, hopefully we didn't go too much over your time. Any questions? Oh, Kayla?
Yeah, on the working while on leave, the DC, that's FMLA temporary.
FMLA, temporary disability, I'm just like that. Yes. On any leave that says you are too sick to work, yes. Yes, Jean?
You answered a question for me recently that I think might be beneficial to other managers. The question was, if someone's out 5 days of bereavement leave, do we count each of those against their limited number of personal, discretionary, whatever? Is it counted against the total? You said to count as one incident.
As one incident, yes. Because when you're looking at evaluating attendance at the end of the year, because I think on our performance appraisal form, it addresses attendance. And if a person is out, let's say they had that twice, unfortunately twice in the family, you know, you wouldn't say, wow, they were out, you know, when you're looking at attendance, that's 10 days. You know, that's two separate incidents, so that's what we're talking about. Count the 5 days as one incident.